Muted.
Started?
Sure. Thank you, Brittany. Good morning, everybody. I wanted to start off by thanking DOT for the invitation to present some training for you that we believe is going to be mutually beneficial for obtaining effective and efficient permits. Before we get started, I wanted to give you a brief geographic presentation, kind of where we are and how we're set up at the Corps. We're coming up on our 1-year anniversary of a reorg that we did that effectively started the FDOT dedicated Corps permit team. And if I could point out on the map here that was downloaded from our website, the FDOT team is located in North Branch. And the stars that are on the map are basically where we've got FDOT dedicated staff. We've got myself, I'm in Panama City. I'm the section chief over the Panama City office, as well as I oversee the FDOT team. We're bringing on a WRDA-funded position, an admin position, and her name is Sue Maxwell. She's also located here. And then in our Jacksonville office, we've got Randy Turner and Mike Ornella, who you'll be hearing from today, as well as Deb Wegman, who is our branch chief. And then to the south, we've got Terry Ostrovsky, who is actually located in our Corps Palm Beach Gardens office. So we feel that the team has a good geographic coverage of the DOT various districts. And if we could, Mike, hit the next slide, please. And these names should look familiar to you. As far as the current breakdown of workload, I've got Randy Turner, who's our senior PM dedicated to districts 2, 3, and 5. And then Terry handles our southern region, districts 1, 4, 6, 7, and the Turnpike Enterprises. And then Mike is he's a floater as needed, and picks up projects in both areas, in the north and the south. So I look forward to a productive session today. If you have any questions, please save them for the end. And if something comes up later, any of our staff are happy to answer questions in the future if something comes up. So with that, I'm going to turn it over to Mike Ornella to start. And thank you very much again for your time.
All right, good morning, everyone. As Amy said, I'm Mike Ornella, located in Jacksonville district office. Floater throughout the state, everywhere from the Panhandle down to Miami. Today, my presentation is going to be on our applications and our nationwide permit program. That'll be followed up by Terry, and she will take over standard permits and the specific regional general permit 92. So the first thing that we can look at here is our ENG 4345, which is our standard application document. I'm sure most of you have seen it, most of you have filled it out, and we can take a look at it in depth, of course. 1 second. So we had a broken link. But this form is the one we look at that's going to have all the information that the Corps needs for its permitting process, and there'll be some tips and tricks here as we look at it to provide a complete application to us so we don't go back and forth multiple times. So mostly the form is very, very straightforward. I'm not going to go in depth one by one. So 1 through 4 by the core. Here's everything that you guys will need to fill out. Applicant name, your authorized agents, the address of your office, agent's address, very standard stuff. In the statement of authorization, that's authorizing the agent to act on your behalf so we can have communication with them. But most of the time when dealing with FDOT, we are keeping the DOT project managers in the loop, and that becomes less of an issue. But this is somewhere where we need to have at least a signature of some sort. And beyond that is the project or activity. Project name, we can use the FPN number, the roads, intersections, bridges. We have our naming conventions, and we try to stick with it and keep a continuity with FDOT. The water body is pretty easy. You're going over a named creek, is the wetlands within a slough. The lat long, we want decimal degree format, and I'll give an example in the next couple slides about that. Project street address, many times this is not going to have an address, a long roadway. That can be skipped over, really, if there's no specific address. Then here's your other location descriptors, and those can be filled out. Directions to the site is usually done from a main highway. So from 95, take exit X to 5 miles down on the south side, something along those lines. Just make sure it comes from a major roadway where it would be easy to find. Your description of your project, all your features, everything you can get in here will be as descriptive as possible, keeping in mind we might ask you for more depending on how much or how little you put in there. Project purpose, a lot of this can be linear transportation, capacity improvements, bridge replacements, safety, that can all be included in 19. Dredged or fill material here in 20 to 23. We have the reason for the discharge. It's going to be bridge abutments. It's going to be grading of a road, culvert placements. And then here's some very important information. The cubic yards, try to be as specific as possible here in these areas where you want to get as many of these boxes filled out as you can, because these are part of the things that go into our permit process and into our permit instruments themselves. And then the surface area of acres of wetlands or water spilled, same thing. 23, your avoidance, minimization, and compensation. That's going to be relatively straightforward. How have you avoided? What did you minimize? And if you can't, what have you done as far as a compensatory mitigation plan for that? Portion of the work already complete, not really a big issue most of the time. But if you do pick yes, we can figure out what has been done. For adjoining property owners, this is mainly for standard permits. For nationwide permits, we're not going to really require that unless there is a large issue that comes up. But for the most part, adjoining property owners are only for standard permits. You can put here your state permits that you may have received and anything or any other federal authorizations you have got. And then this is the main signature that you're going to need, because that pretty much says you are the authorized entity to do this work. We can go forward and give you that permit. And then your agent can sign as well. So that is the end of the ENG 4345. It's a pretty straightforward document. There's not a ton in there that's really going to trip you up, but getting a set of eyes on it is always nice. So when I said about the project description, if there's not enough space on that ENG 4345, an environmental narrative should be submitted with the application, and that will help us fill in all the holes that may have not fit on the application itself. And I know that a lot of you already have these environmental narratives submitted all the time. They're very, very descriptive, very helpful in our decision-making process. The lat long, how I said earlier, decimal degree format, that's the example. And if you go to that, I think that lat long will put you on Colby's head over in Chipley. So another thing, we have a joint application with the state, and recently we have a federal supplement that comes out because federal authorization is going to be required for your work in addition to the state of Florida. So this supplement can be submitted with Section A of the joint application, the authorization for submerged lands, and the federal dredge and fill permits. And what it is a 5-page document that has an additional information that the state or the joint application does not cover completely. So that is something to be aware of, that the federal supplement should be added when applying through state. As far as applications and where to go, we have a dedicated mailbox that's written down here, corjaxreg-FDOT at usace.army.mil, and this is monitored by our FDOT team and is going to be the fastest way for us to receive those applications. Unfortunately, our email system has a 10 megabyte limit, and anything greater than that, we suggest you use the Safe Access File Exchange system, and that way we can get the larger files in their downloads. A quick tip on Safe is to always include that Corjax Reg FDOT mailbox so that there is a secondary catch on making sure they know that file has been transferred. So projects are input and tracked by the FDOT and the Corps in SharePoint. So that's it pretty much for the applications. It's not too hard, it's not too intuitive, it's very straightforward for the most part. And we're always available to answer questions on those applications as you fill them out, or as your consultants, agents fill them out as well. I'm glad to help. So moving on to nationwide permits. This is our nationwide permit program. Some examples of things we permit through our nationwide permits there. So we're going to go over a couple things. What's a nationwide? We'll go over some specific nationwides and the general conditions, the contents of pre-construction notification, our regional and special conditions, and then we'll talk about the expiration of the nationwides, which is coming up right around the corner. So nationwide is a general permit. It's always minimal impacts, usually less than 1/2 of an acre. These nationwides are issued by our headquarters every 5 years. Last one's done in 2012, so that means they're expiring 2017, next month. It authorizes activities across the whole country, so we're not specifically here in Florida. They have their general and regional conditions, which then brings the specificity down to Florida to form those nationwides to fit our program here. So the process for issuing nationwide is a rulemaking activity. And like I said before, the most recent version published on March 19th and set to expire on March 18th, 2017. And we will get into what that means in a little bit. So nationwides are an expedited 45-day review process for minimal impacts. Examples that we utilize are utility lines, transportation, bank stabilization, commercial institutional development, repair and maintenance of existing structures. Those are the ones that we will see most likely with FDOT projects. Here is a whole list of the 2012 nationwides. You can see there's 52 of them, probably 51 because there's one reserve spot. A lot of them are very odd. You can see there's nationwide permit number 34 is for cranberry production activities, so it's very specific for, in some parts of the country, probably very useful. Not here. But there's some of those that we might use very sparingly. We'll go over a couple of those just quickly. But for the main ones that we will be utilizing with FDOT, the first one, Nationwide 3, maintenance. This is Section 10 and 404. The biggest thing to take away from maintenance is that the structure or fill is serviceable and previously authorized. So that pretty much means there has to be a permit somewhere from the Corps saying this was authorized at some point. You can't have a different use of the project. It authorizes temporary structures around for that maintenance. And then the PCN, pre-construction notification, is required for removal of accumulated sediments. One thing to also note about the 3 is that it will account for minor deviations, but very minor, can't change the use of the structure. But if you need to add a little bit for a safety improvement, it's possible that that would qualify under Nationwide 3. The next one is the 6, which is survey activities. Also Section 10 and 404. This includes stuff like core sampling, trenching, sample plots. It does authorize temporary pads. Does not authorize fill for roads or permanent structures. And in the 2017 nationwides, there will be a new pre-construction notification requirement for manatees. In the past, manatees, as long as you weren't doing seismic exploratory activity, you could go forward, utilize the nationwide permit number 6 without notifying us. But now the regional conditions have changed to where PCN will be required for nationwide 6 use no matter what activity it's going to be. 12 is the utility lines. This is going to be any sort of utility line from pipes to overhead wires and cannot result in the loss of more than half an acre, as with most of the nationwides. Authorizes temporary structures fill and work for those construction of the lines, and this also can be used to authorize substations in foundations and temporary and permanent access roads. Now the half-acre limit needs to be kept in mind for those temporary and permanent access roads as well. So pre-construction notification required if there's going to be land clearing in a forested wetland, if a Section 10 permit is required, utility lines in waters exceeds 500 feet, it's in a jurisdictional water and runs parallel to a stream bed within a jurisdictional area, the loss in greater than 1/10 of an acre, permanent above grade access roads in waters over 500 feet, and permanent access roads and waters constructed from impervious materials. So we need to emphasize that loss there in capitals is permanent fill. Temporary fill is not considered a loss of waters. And we'll talk a little bit more about that as well. Here's another common one we'll see with bridge replacements and certain roadway projects. Is the 13, which is bank stabilization. Mostly we see this as single-family homes or putting in a new seawall, but this has a limit of 500 linear feet, which can be waived, and waiver process is a little bit in extra work. That's saying, hey, you've gone over 500 feet, but it's 510. It's still a minimal impact. You have to have less than a cubic yard per running foot below ordinary high water, high tide line, which also can be waived. Not authorizing discharges in special aquatic sites also can be waived, and cannot impair surface water flow. Can't put it somewhere where it's going to be eroding, and you cannot channelize streams with the Nationwide 13. So the three things that will require a PCN, special aquatic sites, excess of 500 linear feet, in excess of a cubic yard per running foot. Another one to note in there is endangered species issues, which will be kind of a catch-all in all the nationwides, is PCN required for endangered species issues that will arise. You can see the riprap here placed in the waters, kind of a common shoreline stabilization effort. Here's the one that FDOT and the Corps are going to utilize probably most often, definitely most often. It's the linear transportation projects. That includes all your temporary structures and work. In non-tidal waters, there's a limit of half an acre. In tidal waters, that limit has moved down to 1/3 of an acre. Stream channel limited to minimum necessary, and this does not authorize non-linear features like storage buildings, parking lots, train stations, or aircraft hangars. Then again, PCN required for greater than 1/10 of an acre, discharge in special aquatic sites, including wetlands, and ESA issues. So that almost guarantees that a PCN is going to be required for all submittals for the Nationwide 14. This one is kind of a vague one that could be utilized under certain circumstances. Nationwide 39, commercial and institutional developments. Note that it is non-tidal. Building pads includes features like roads, parking lots, stormwater management facilities, and recreational facilities. And half an acre limit, 300 linear feet of a stream bed. And if that stream bed is intermittent, that will not be waived. Can't be used for golf courses, ski areas, and oil and gas wells. And you cannot use it in non-tidal, adjacent to tidal. A PCN is required for those. So a few less common nationwide permits that we might run across is the Nationwide 15, which is the U.S. Coast Guard approved bridges. The Coast Guard is responsible for permitting bridges. The Corps is responsible for the bill associated with the run-ups, the abutments, the shoreline stabilization, but we are not in the business of putting a bridge in a water. Coast Guard is the lead on that and will be responsible. Nationwide 33, temporary construction access and dewatering. This is for maintenance areas. You got to dewater around a seawall to run some maintenance on a footer. Those are less common, but we do see it. The 41 is the reshaping of an existing drainage ditch. If you're going to be moving it over, we can, if it doesn't fit under the 14, we can work on figuring out a way to get that under the nationwide 41. And then the 46 is also discharge in ditches, and that will be a case-by-case basis as it comes along. Here's all the general conditions for the current nationwide permits. We're going to go over a couple of specific ones here, but see there's quite a few pretty specific subjects that the conditions hit on. So number 15 is a single and complete project. This means that it needs to have independent utility. And the test to determine what constitutes a single and complete nonlinear project, the project has independent utility if it would be constructed absent of the construction of other projects in the project area. Portions of a multi-phase project that depend upon other phases do not have the independent utility. The same nationwide can't be used more than once for the same single and complete project, but two or more different nationwides can be combined to authorize a single and complete project. So if you have a nationwide 14 for a road and a nationwide 13 for a bank stabilization, those could be combined because that project would be single and complete, just requiring different authorizations. More about single and complete. The single and complete linear projects, so what we will see most often is the portion of the total linear project or accomplished by one owner or developer includes all the crossings of a single water of the U.S. at a specific location. So for projects that are crossing multiple water bodies several times at separate and distant locations, we can consider each crossing a single complete project for the purposes of a nationwide authorization. It can be confusing, but if you see it on a map and realize those are separate and distant crossings, we can authorize a nationwide 14 for each one of those. But another thing is you cannot piecemeal a project to avoid limits of a nationwide permit. So that half-acre limit, you can't piecemeal a bunch of projects and say, well, these qualify because they're under half an acre each. Well, it's a single and complete project, so we're going to need to elevate it to a standard permit if that's the way it's going to go. So endangered species, we can't authorize any nationwide permit that is likely to jeopardize the continued existence of a species or that will adversely modify the critical habitat. No activities authorized under a nationwide permit which may affect a listed species unless that Section 7 consultation has been completed with Fish and Wildlife, National Marine Fisheries Service. Federal agencies need to follow their own procedures, and most of the time when FDOT is submitting applications to us, a lot of the work for Section 7 has been completed either through federal highways or now the delegation of FDOT having the NEPA delegation delegated down to them. So we will look at the consultation that was completed and determine if the documentation is sufficient or if we need to go further and get some clarification or consult farther on those species. No work is going to begin until notified by the Corps that requirements of the ESA have been satisfied, and your activities authorized. And there's a possibility, most likely, that the Corps will add species-specific regional conditions to our nationwides. There's 2 links there at the bottom for Fish and Wildlife and National Marine Fisheries Service for more information on species, especially ones in your specific areas. Just like with endangered species, historic properties need to have their own consultation, and we need to meet requirements of Section 106 of the National Historic Preservation Act. Your PCN needs to state which properties may be affected if you know of any in the area, and you cannot begin the work until that Section 106 consultation has been completed. General condition number 23 is mitigation. So your first step is to avoid and minimize all temporary and permanent adverse effects to the maximum extent practicable. Compensatory mitigation is going to be at a minimum of 1-for-1 for all wetland losses that exceed 1/10 of an acre and require PCN. For wetland losses of 1/10 of an acre or less that require pre-construction notification, it can be a case-by-case basis on whether or not mitigation is going to be warranted in each one of those cases. So a note on that is the 1/10 of an acre threshold is the functional loss resulting from project activities. So using a functional assessment, or not including temporary impacts, as long as they're regraded, vegetated, and everything will all play into your compensatory mitigation plan and whether or not the Corps will accept it. You can't use mitigation to increase acreage losses allowed by the limits of the nationwides. Near streams, we need most likely include establishment maintenance and legal protections such as conservation easements of those riparian areas next to open waters. The permittee may use mitigation banks in lieu fee arrangements or activity-specific mitigation. In all cases, mitigation Corps' kind of hierarchy of mitigation is we're going to want you to go mitigation bank first, in lieu fee second, and then after that, permittee responsible under a watershed approach, permittee responsible on-site and in kind, and then at last resort, permittee responsible off-site and or out of kind, which is one we want to avoid at all costs if possible. So mitigation may also be required when functions and services of a water or wetland have been permanently adversely affected. So if you're converting a forested wetland system and you're mowing it down and pulling the trees so it becomes a herbaceous wetland area, we will likely be looking for mitigation for that functional loss because those two types do not share the same functional. So then the pre-construction notification, PCN is required. We must determine if it's complete within 30 days of receipt, and as a rule, request additional information only once. A lot of times, a formal request for that first RAI will scatter over into specifics into a couple emails. No work is not going to begin until you're notified in writing by the Corps, which we can include those special conditions, and if 45 calendar days have passed from the receipt of a complete PCN, provided there are no ESA issues. And with the Eastern indigo snake, there's likely going to be ESA issues across the whole state. Even if the 45 calendar days passed and the applicant can begin work, they're still going to be bound by all of the nationwide permit general conditions. So all those, that list that we just went through are all applicable if you begin the work. So general condition 18 or 20 is going to require a PCN. You can't begin the activity until the Corps tells you no effect on the species or no potential to cause effects on the historic properties, and or the fact that we completed consultation with Fish and Wildlife, NMPS, or the State Historic Preservation. And then we talked about waivers a little bit. If the activity is going to require a waiver, there is no work to be started until the Corps issues that waiver and subsequently the permit authorization. PCN, basically the ENG 4345, all of the information we went through over that. The note at the bottom, make sure it's sufficiently detailed, which you can have the environmental narrative assist with that. And then project drawings, I'm pretty sure that's not a problem. We haven't had that issue, but they need to show that the activity and work complies with the terms of the nationwide. Delineation is big because we need to know, what we're regulating and what's on your project site that we're going to be regulating. The delineations should be prepared with the current method. And a completed preliminary jurisdictional determination form submitted with the application package is going to be very useful, and will keep us from maybe asking extra questions. So if the loss is over 1/10 of an acre, the mitigation requirement should be submitted with the application, notifying us what your plan is to mitigate for those loss functions. Once again, the endangered or threatened species that could be affected by the work, a lot of times federal highways and Fish and Wildlife, NMPS, all that will be coordinated before application. And then the same with historic properties. So regional special conditions, applicants must comply with any regional conditions of our district, and make sure you're always checking the regional conditions as well as the general conditions. There's a link to our source book where you can literally find almost everything you need to know about our program, including the regional conditions will be listed under the nationwide permits to show you what specific conditions we will have in this area based on our endangered species and or wetland requirements. So we can add special conditions to the verifications, and they'll always be clear, concise, and enforceable. Notifying, we'll always make sure that you're aware of what we're going to be adding. Most of them in our area will be endangered species conditions. So like I said earlier, the 2012 nationwides are expiring March 18th. If this nationwide, so say take our cranberry one for example, if it doesn't, no one's using it, if it's not modified or reissued in this 5 years, then it's going to expire and becomes null and void right away. One thing to note, if your activity has commenced and is under contract to commence, your authorization is valid for 12 months from the date of the expired permit. So currently for the ones that are expiring now, if you're currently under construction, you have until March 18th 2018 to finish your project. After that, work is still not done, a re-verification on the new nationwide permits will be required. Our FDOT team has developed an expedited review process for the new nationwide permits once the 2017s are finalized. So we want to make that a smooth transition as possible for all of those permits that have not been begun work or are under contract. So we worked very hard. Turner's actually made a big step in getting us on the right track to the smooth transition from the 2012s to the 2017 nationwides. And we'll work with you and make sure everything flows nicely. And so we've been receiving lists of nationwides requiring the renewal. So that is it for my section about nationwides. And I think we can send it over to Terry for the next part.
Okay, hopefully everybody can see my screen. My name is Terry Ostrowski, and I'm located in the Palm Beach Gardens office. And as Andy mentioned, I work on projects within the boundaries of Districts 1, 4, 6, 7, and the Turnpike. And this morning, I will be explaining some of the other forms of permits, with the first being regional general permits. And these permits are another form of general permit and are similar to the nationwides, whereby they are issued by the Corps. They authorize a category of activities that are substantially similar in nature and cause only minimal individual and cumulative impacts to the environment. Each of the regional general permits includes a list of activity-specific terms and conditions, and also general and regional conditions, which are all applicable to all of the regional general permits. The impact thresholds authorized under a regional general permit may be greater than the nationwide permit limits. And like the nationwide permits, these regional general permits are each authorized for 5 years. It's a bit different than the nationwides, where the nationwides have a blanket of permits. Under the regional general permits, each has its own specific issuance and expiration date. There are multiple regional general permits, and you can view a list by accessing the source book at the link that Mike had just shown. But the regional general permit that I'm going to talk about today is the SAJ 92, as this permit is utilized specifically for FDOT and Turnpike projects. The version of the SAJ 92 that we are currently working under was issued on 8 April 2015, and is authorized for 5 years, with the expiration date being 8 April 2020. There has been one modification, which occurred on 1 September 2015. The modification is in regard to mitigation, and this is included under Special Condition Number 10 of the permit. The initial SAJ 92 stated that for unavoidable permanent impacts to waters of the U.S., mitigation will be required to the purchase of credits from federally approved mitigation banks or in lieu fee programs, and that permittee responsible mitigation would only be considered when project impacts are located outside of the service area of banks or in lieu fee programs, or if the appropriate number of credits is not available from these entities. The 1 September 2015 modification to Special Condition Number 10 provides the flexibility for the applicant to propose mitigation through permittee responsible mitigation if the permittee can demonstrate to the Corps that the mitigation proposal is the environmentally preferable option to replace the ecological loss of functions and services which would result from the proposed activities. The SAJ 92 contains multiple terms and conditions that a proposed project must meet in order to qualify. And one is the requirement that a pre-construction notification be submitted to the Corps. This can be through the submittal of the ENG form or the supplemental form, which Mike discussed previously. Another condition is that the project must have been evaluated and approved through the ETDM or PD&E process subsequent to 2010. This requirement includes projects that were initially evaluated prior to 2010, but have undergone reevaluation and approval subsequent to 2010. It's helpful to the Corps if the applicant includes this information with the application so that we can accurately identify if the proposed project would meet this requirement. And this can be done through the inclusion of a letter with the approval and the date so that we know that this would meet this condition. Another condition is that the project must not result in a loss of more than 5 acres per linear mile. Remember, this refers to loss. There may also be temporary impacts proposed, but these would not be included in the 5-acre loss calculation. The temporary impacts would be included with the overall impact calculation, but just not as a loss. The temporary impacts would have to be those which are restored to pre-construction conditions. Also, it's helpful for the Corps if the applicant includes a table that identifies the impact acres per linear mile so that we can accurately determine if a project meets this loss requirement. In some cases, you may not need to. For instance, if you are proposing 4 acres of loss and your project is 2 miles, well, even without being, it could just be 1 mile, and then we wouldn't need the form. But if you are proposing 7 acres of loss and your project is 2 miles, then your first mile may include 6 acres and your second 1 acre, so we wouldn't know unless we had an example of what your acres are per mile. Another condition is that the overall loss of waters of the U.S. is 50 acres. Again, this refers to loss. Compensatory mitigation is required to fully offset all impacts to waters of the U.S. in accordance with the mitigation rule and as discussed during the previous slide. And the authorities under the SAJ 92 include Section 404 and Section 10. However, Section 10 refers to non-tidal navigable waters only. The SAJ 92 does not authorize work in tidal waters. That's a very important condition to remember. The SAJ 92 authorizes both non-capacity and capacity projects. The non-capacity projects refer to projects which propose activities such as safety improvements, roadway maintenance activities, addition of bike lanes and sidewalks, etc., as the lower left picture reflects. And capacity projects generally refer to projects which propose the addition of travel lanes, such as roadway widening projects, as the picture on the right reflects. But I know you all have a better understanding of capacity and non-capacity projects than I imagine the Corps does. The SAJ 92 also identifies activities that are not authorized. And these include stream channelization or bank-to-bank filling, and the relocation or culverting of more than 300 linear feet of perennial or intermittent natural stream systems. Natural stream systems do not include ditches, canals, swales, or other man-made non-natural systems. And I've been in Florida for over a year, and I haven't seen very many natural stream systems. Proposed activities must not increase flooding. A project must not impact the pre-construction hydrology or water quality of a stream. The severance of upstream and downstream connections are not authorized. Projects proposed in Monroe County are not authorized. And a very important condition to be aware of is that the SAJ 92 does not authorize the construction or establishment of new roadway alignments. And that means that non-existing roadways. As with all proposed projects, the Corps is required to evaluate the potential effects that the project may have on endangered species and their habitat, as well as on cultural resources. And Mike also talked about this for the nationwides. For Section 7, evaluation and determinations may be carried out through the use of programmatic agreements, using keys, or through informal or formal consultations, depending on each particular project and the species that may be affected. And as Mike mentioned, consultations may have already occurred prior to submittal of an application. The same holds true for Section 106 with the consultation process. And if the Corps determines that there is a potential effect on cultural resources, the Corps would consult with the State Historic Preservation Officer, or the SHPO, and potentially the Tribal Historic Preservation Officer, or the THPO, if a proposed project may result in adverse effects to cultural resources that have a religious or cultural importance to federally recognized tribes. There may be occurrences where mitigation would be necessary for cultural resources to offset effects, which is generally through the execution of a memorandum of agreement. To assist the Corps with evaluation of the potential effects on ESA species and cultural resources, it's extremely helpful if a copy of the Cultural Resources Assessment Surveys, biological opinions, consultation letters, any kind of coordination that the applicant has done would be included with the application materials. The Corps may still need to consult with the agencies. However, this will provide information to the Corps of the prior consultation and of any determinations that may have been made by the agencies. There are additional terms and conditions within the SAJ 92, but the ones I've mentioned are the conditions that I felt were critical to point out and to help you to quickly identify if a proposed project may fit within the parameters of the SAJ 92. And to review all of the terms and conditions of this permit, you can go to the Sourcebook website and select the link for the SAJ 92, and you'll be able to view the entire permit document and all the conditions that it carries. Okay, so once the Corps has evaluated the project and resolved all issues regarding Section 106 and Section 7, the Corps can issue a verification letter under the SAJ 92 permit. This would include the letter with the authorized work description, a list of project-specific special conditions, and general and regional conditions. The special conditions may include ESA conditions, for instance, in water work, as-built plans, things like that. Also, the project plans will be included as an enclosure. And as mentioned, the expiration date for the authorized work is 8 April 2020. However, like the nationwide permits, if the project is under construction or under contract to commence construction prior to 8 April 2020, the permittee has 1 year in which to complete the work. And then the work must be completed by 8 April 2021. And just like the nationwides, if the work cannot be completed by that time frame, then the project would need to be reevaluated and would need to receive a verification under the new SAJ 92 if one is issued. So, what if a proposed project does not meet the terms and conditions of any nationwide or regional general permits? The Corps would evaluate the project as an individual permit. And there are two forms of individual permits, which include the letter of permission and the standard permit. The letter of permission, or LOP, is an abbreviated process which is used by the Corps to authorize minor projects, meaning projects that would not result in a significant environmental impact, and projects which are not anticipated to instill opposition or controversy. There's a specific list of activities that may be authorized under an LOP, some of which include construction of small platforms, mooring dolphins, maintenance dredging, things like that. The LOP process requires issuance of an abbreviated public notice, meaning the notice is only sent to the adjacent property owners and the agencies, and the comment period is only 15 days. The activities that are authorized under an LOP are not typical of linear transportation projects, but we just wanted to make you aware of this form of individual permit. And the other form of individual permit, and the process that is often used to evaluate transportation projects, is the standard permit. Because a project does not meet the previously mentioned permit types of the nationwide or the regional general permits, as you are aware, those permits are determined to result in minimal individual and cumulative impacts on the environment. Since a project would not meet that, then it would be viewed as proposing a more than minimal impact on the environment. And this is basically the final permitting option. There are no specified impact acreages or linear feet limits to waters of the U.S. The proposed impacts are evaluated on a case-by-case basis for each single and complete project, and Mike talked about that in his presentation. Due to the potential complexity of a proposed project, pre-application meetings are highly encouraged and are beneficial in identifying issues early in the project review process. The form of pre-application meeting often does occur through the ETDM process. However, in addition to that, field reviews and interagency meetings are also encouraged. And finally, since these projects are viewed as resulting in a more than minimal impact on the environment, the standard permit process involves a more involved review and evaluation of the proposed project's effects, which is performed through an environmental assessment, or EA. And the EA includes information regarding public involvement, an alternatives analysis, review of cumulative impacts, etc. And again, because of the complexity of these projects, there are many steps involved, with the first step being, of course, review of the application for completeness. And as with the other permitting mechanisms, the application may be in the form of the ENG form or the supplemental. Once the application is complete, the next step is that the Corps will issue a public notice, and this fulfills the Corps' requirement of public involvement. Coordination with the agencies such as U.S. Fish and Wildlife Service, National Marine Fisheries Service, the SHPO, and the THPO if necessary, as well as the applicant, generally occurs in conjunction with the public notice comment period. As mentioned, this process also involves the Corps writing an environmental assessment to evaluate the potential effects. And when all of the mentioned steps have been completed, the Corps will make a final action determination. And I'll briefly discuss these steps and explain what's involved with each now. So the first step, application completeness. The requirements are similar to the other permitting mechanisms. The project description should be clear and complete and should include, I'm sorry, I didn't change the slide, there you go. Clear and complete, and should include information such as the total roadway, length, where work is proposed, the beginning and ending locations, perhaps mile marker locations or stations, that's helpful. What activities are proposed, the acreages of permanent and temporary impacts, the overall project area acreage, impact tables showing the resource names and their coordinates with the impact acreages, and if it's permanent and temporary, that's very helpful. Also plans that show where the waters of the U.S. are in relation to the proposed work. For instance, if it's a roadway widening project and the proposal is to impact a wetland, the wetland being overlaid with the roadway is what we would be needing to accurately identify the project. The Corps and the public should be aware of what impacts to waters of the U.S. are proposed and where. The location information, which includes the center coordinates, are necessary. The applicant's purpose and need statement, avoidance, minimization, and mitigation efforts, and the signature of the application. These are all required. And the other item that's required that, as Mike indicated, are not necessary for the nationwide permits, and also they're not necessary for the regional general permits, is a list of the adjacent property owners. And the reason that the Corps needs this list is due to the requirement of the public involvement through the issuance of a public notice. It's helpful if actual labels are provided to the Corps, especially if it's a project of quite a length where there are multiple adjacent property owners, or at a minimum, if the applicant can provide the labels in a Word document format. That's easier for us to print. If it's in a PDF, it doesn't generally line up, and then we end up having to copy and paste. It's just more challenging. And if the necessary information is not provided with the application and it is deemed incomplete, the Corps will send a request for additional information letter, either through letter format or by email. And this is referred to as an RAI. Mike also talked about this with the nationwide. It's the same for all permitting reviews. And we generally do request the information be provided within 30 days to ensure the review continues in a timely manner. If the information is not received within the 30-day time frame, if that's what we had selected as the time frame, the Corps would administratively withdraw the project and then reopen the file upon receipt of the required information. Withdrawal does not mean that the process stops or starts over again. It just means that the Corps is aware of the active projects and that this project would immediately reopen once the information was received, and review would continue where it was left off. Okay. So once the application is complete, the Corps will then prepare a public notice. And as stated, the public notice fulfills the Corps' requirement of public involvement. And the purpose for the public involvement is to solicit comments and information from the public in order for the Corps to evaluate the potential impact of a project on the public interest. The information included in the public notice must be sufficient to generate meaningful comments and provide a clear understanding of the nature and magnitude of the proposed activity, which is why a clear description of the proposed work, waters of the U.S. impacts, location, and project plans are necessary. The comment period is between 15 and 30 days. 30 days is generally used for projects that are large scale or potentially controversial, and that's to make sure that the public has a sufficient amount of time and opportunity to submit comments. If a comment period is too short, the Corps may receive a request to extend the comment period. But I would say that 21 days is a common number of days for non-controversial projects. This slide shows a list of the items that the Corps is required to include in the public notice. I won't go through each one on the list, but I have highlighted the items that the Corps would find on the ENG or supplemental form, as well as we would find it in the enclosures that are generally submitted with the application, such as the environmental narrative, the ESA and EFH surveys, project plans, JD forms, things like that. And let's see, regarding the compensatory mitigation statement, the applicant is required to explain how unavoidable impacts to waters of the U.S. are to be compensated for in accordance with the mitigation rule. If compensatory mitigation is not being proposed, the applicant must include a statement explaining why mitigation should not be required for the proposed impacts to waters of the U.S. And also, just as a reminder, if you propose to purchase credits from a mitigation bank, then the resources must be evaluated using the same functional assessment methodology as what's used by the bank. The other items on this list are basically standard paragraphs that are included on each public notice, with minor variations such as the project manager name and phone number, the authority of Section 10 and/or Section 404, things like that. If the districts and the Turnpike are interested in receiving a copy of our public notice template, you can see just the first page of the template right there, just so you can kind of see how it's laid out. The Corps can provide that to you. If you'd like to try to fill out some of the sections and return it to the Corps, we could definitely provide that to you. And just also remember, the information that's included in the public notice, this is provided by the applicant. And no decision has been made at this point regarding authorization of impacts and or mitigation. Okay, so now the public notice is posted, and a letter identifying that a notice has been posted to the Corps website and how to access the website to view the notice has been sent to each of the adjacent property owners. And again, that list is provided by the applicant. Also, the Corps sends out an electronic notification to all individuals on the electronic mailing list. This list includes all of the individuals who have requested to be informed whenever the district posts a public notice. And many of you may actually be on this list and receive notice every time a public notice is posted. Additionally, agency consultation may commence at this point with the initiation of an informal or formal consultation letter with a copy of the public notice being attached to the letter. Regarding Section 7, the evaluation process is the same as for the previously mentioned permitting mechanisms, meaning the Corps may use programmatic, informal, formal consultation, or perhaps consultation has already been performed prior to submittal of the application. And again, as Mike mentioned, that maybe additional coordination would be required even if prior coordination did occur, but this is determined on a project and species-specific basis. Regarding Section 106, the SHPO receives a copy of the public notice and plans automatically through the electronic notification process. However, if the Corps has determined a potential adverse effect on historic properties, then the Corps would consult with the SHPO through a consultation letter and potentially the THPO, as I had stated during my overview of the SAJ 92. The EPA also receives a copy of the public notices through the electronic notification process, and they may provide comments and or request a site visit. In these cases, the Corps would coordinate directly with the EPA and schedule site visits and discuss and resolve the concerns. If a proposed project would affect a federal navigation channel, regulatory would coordinate with the Corps Navigation Branch. And pursuant to Section 408, if a project proposes to alter or temporarily or permanently occupy the U.S. Army Corps of Engineers Civil Works project, the prospective permittee must receive permission from the appropriate Corps to do so. For the Jacksonville District, the appropriate Corps office is the Engineering Division, and a Department of the Army permit cannot be issued for the project until the Section 408 review is completed and permission is provided through a letter from the Corps. Okay, so once the public notice comment period has completed, the Corps will prepare a letter to send to the applicant, which includes all of the comments received during the comment period. The Corps will include a brief summary of the comments in the letter, state any additional information that we may require as a result of the public or agency comments, and attach a copy of all of the comments, all of the comment letters to the letter that we send to the applicant. The Corps will request that the applicant respond to the comments, if necessary, within 30 days. There are incidences where no responses are needed if no questions are raised, and in these cases, no response from the applicant would be requested. If responses are necessary, the Corps will review the applicant's letter to determine if the information is complete, and will provide the responses to the commenters when it's appropriate to do so. The applicant may also elect to contact commenters directly for questions that are not within the Corps' purview, such as sound walls, potentially drainage, flooding, things like that, that the individuals are concerned about their properties, and noise. The Corps asks that we be included as a CC if the applicant does decide to contact the commenters directly, so that we can be aware of the responses and the coordination. And as you may have seen on the list of items a few slides ago that are required to be included in the public notice, there is information related to how the public may request a public hearing. If one is requested by the public, the requester must state with particularity the reasons for holding a public hearing. The purpose of a public hearing is to acquire information or evidence not otherwise available that would enable the Corps to perform a thorough evaluation of the issues. Whether or not to hold a public hearing is at the discretion of the district commander. If it's determined that a public hearing would not result in the introduction of new information, the request would be denied. If it is determined that a public hearing is required, there are special guidelines that the Corps must follow in order to perform that function. And as stated previously, due to the view that the project would result in a more than minimal impact on the environment, the standard permit process involves writing an environmental assessment. If a project has been determined to result in a significant impact on the quality of the human environment, then an environmental impact statement would be required. However, the EA is generally the document used for many of the linear transportation projects. That's what we'll talk about. One of the requirements within the EA is an alternatives analysis, and this information should be included in the application by the applicant. However, the Corps does have specific guidance that we must use when writing this section of the EA. We use screening criteria, and this slide shows some of the factors and their measures and/or constraints that we must address. The selected factors may differ in accordance with each project, but some are consistent for all projects, such as the overall project purpose. But if a project does not propose wetland impacts, then we would not be reviewing that factor, things like that. This guidance can be found on the Sourcebook website at the address included at the top of this slide, so that if you all would like to take a look at this format, and if you would like to prepare your alternatives analysis in the format that the Corps requires, that would be a great help to us when we're preparing our documents. Okay, so the EA also includes the Corps' evaluation of the 404B1 guidelines if the authority includes Section 404, which is generally the case for linear transportation projects. There's generally fill within waters. The guidelines include potential effects on the physical and chemical characteristics of the aquatic ecosystem, biological characteristics of the aquatic ecosystem, and other things like that. Also, evaluation of avoidance, minimization, and mitigation efforts are required. And this information was included in the public notice. And when we're writing this document, it may be the same as what was in the public notice, or the information may change if the project had been modified or new information had been provided. Evaluation of cumulative and secondary impacts, which are anticipated to result from the proposed project, are also required. And this includes evaluation of past, present, and reasonably foreseeable future impacts. The EA also includes information regarding compliance with Section 7 and Section 106 and how the project has been brought into compliance if effects on resources were identified. And we would also include the evaluation of all species considered for Section 7. They're all in this document. A public interest review is required for all projects and includes information associated with the previously mentioned topics, as well as several others, such as economics, aesthetics, recreation, and other items. There are additional paragraphs and sections that need to be evaluated within the EA, but I wanted to mention a few and just provide awareness, if you're not familiar with this document, of the magnitude of information necessary to evaluate a project under the standard permit process. And finally, after the project has been thoroughly evaluated, the Corps will make the determination regarding the least environmentally damaging practicable alternative, or the LEDPA, and we will include this determination in the EA. So now the EA has been completed, all concerns have been addressed, and the Corps is ready to take final action. If the Corps has determined that the proposed project is the least environmentally damaging practicable alternative, and the issuance of a Department of the Army permit is not contrary to the public interest, then the final action would be to issue a permit. And there are two scenarios. The first scenario is that the Corps has not received a copy of the state approval or waiver. In this case, the Corps would provide a letter of intent to issue, meaning that the Corps is ready to take final action on the application, but by federal law, no final action can be taken until a state Section 401 water quality certification has been issued or waived, and that the state has concurred with an applicant's coastal zone management consistency determination, or concurrence has been presumed. The letter of intent to issue would include the requirement that a copy of the state's permit be sent to the Corps by the prospective permittee, and then the Corps can issue the initially proffered permit once we receive that state permit. In the second scenario, the Corps has received a copy of the state permit. Therefore, the Corps would issue an initially proffered permit to the prospective permittee. And this includes the permit form with the authorized work description, a list of the project's specific special conditions, general conditions, plans, and any other applicable enclosures such as the ESA protection measures, the as-built plan certification form, things like that. At this time, the prospective permittee has opportunity to review the permit form and to discuss special conditions with the Corps if they have concerns. If there are questions, we will talk about them and try to resolve them. However, if the prospective permittee agrees with the special conditions, then they will sign the permit form and return the form to the Corps for countersignature. If there's more than one permittee listed on the form, then all must sign prior to returning the form to the Corps for countersignature. Once the Corps receives the signed permit from the prospective permittee, the Corps will then countersign and return the complete permit document to the now permittee. And this is considered to be the proffered permit. It should be noted that the permit is not authorized until it is countersigned by the Corps. The standard permit authorization timeframe will be included within the permit document and is generally for 5 years. Now, speeding ahead 4+ years from the permit issue date, an expiration is getting close. If the permittee finds that they cannot complete the work within the 5 years, they may request an extension to the expiration. The request must be received by the Corps prior to the expiration date of the permit, and the Corps will evaluate the request to determine if authorizing the extension would be appropriate. Now, these steps that I've talked about, those are when the project has been determined to be the least environmentally damaging practicable alternative and the Corps issued a permit. So what happens if it's not the LEDPA? Then the final action by the Corps would be denial, and that has its own process. But in our example today, you now have your standard permit and you can go to work. And now we can answer any questions that you might have.
Okay, so we do have a couple of questions on here. Let me see here. This is one. Brent's question. Okay. Brent, I'm going to turn on your. Well, are we reading it right here? Okay. We're going to go ahead and actually go ahead and read the question. Yeah. So the question is, for projects with less than 1/10 of an acre of wetland impacts, you indicated that no PCN can be done case by case. So do we call the Corps to consult since no PCN may be required?
Well, as we said, that ESA issues are going to trigger PCNs on almost every single project that we come across, mostly because of the eastern indigo snake being a statewide species. But Andy, do you have any input on that one?
Oh, there are, certain few and far between cases that may not have any associated ESA issues. For example, if you've got, say, a ditch that clearly does not have any ESA implications, and you're under a tenth of an acre, that kind of a project, say like a culvert crossing or something, could be subject to the non-PCN, tenth of an acre, less than tenth of an acre.
Okay, well, thank you. Does anybody else have any other questions or anything with the training?
Another question.
Okay.
So we have another question. We generally submit the ENG 4345 as an attachment to the state application. Does the new federal supplement fill this requirement?
Yes, it does. Essentially, the federal supplement was based on the ENG form. So where the federal supplement was out, we were requesting the ENG form to be filled out. But now that the supplement is out, you can use that in lieu of the ENG.
Any other questions? Okay, well, we'll go ahead and wrap this up then. Thank you, everybody, for attending, and thank you, everybody at the Army Corps, for going ahead and putting this on for us today. And we will talk to you all soon. And if you did not send us who was attending, please do that so that way we can make sure you get credit in learning curve. So, thanks again, everybody.